Greetings, programs. Welcome to the Red Pill Sunday School on this fine Sunday. It is October 29th, 2017. Welcome to UCY.TV. Thanks so much for joining us. Us being me, anyway. But I speak on behalf of everyone else here. You know, I like to get right into the subjects. I don't like to waste time. I don't have anything to advertise. I don't have anything to sell you. I don't have anything to offer, and you know, there's nothing attached to my websites. I don't want you to go to any place and buy anything. I just want to teach. That's all I want to do. And so, again, we're going to get right into it today without any hoo-ha. What I want to talk to you today about is, well, I guess we could call it the history of the United States. What is the actual history of, quote unquote, the United States? But that's a very difficult topic to actually speak about in simple terms, because really the United States wasn't, quote unquote, created in its modern form until after the Civil War. The Civil War, which had no end. No peace treaty was declared, and we've been in a permanent state of war under the guise of a national emergency ever since. And we'll cover that in greater detail. But what we have to do, instead of talking about history, you know, you can tune into any old radio station, any old patriot crap that you hear on the radio. They'll tell you about how great the founding fathers were and how wonderful Lincoln was and how wonderful Reagan, and all of these wonderful things that they had to say about the United States, without quite understanding what the United States actually is. It's kind of hilarious to me to, again, watch people wave the flag even as they talk about how government, quote unquote, is enslaving them. I don't quite understand that type of Stockholm syndrome. But okay, let's stick to the facts here. Let's stick to what we know. What is it that we know? Not the history and the personality as the clowns that were in the Congress back then or now. That doesn't matter. What matters is what they create as legislature. What matters is what we can see, what they did that was put onto paper, that stuck as the law of the land, if you will, whatever was created. So that's really the only history that matters. You know, I can romanticize or I can demonize, I can talk all day long about my opinions that are completely unfounded because I have no possible knowledge of what history actually was. But what I can do is I can go to the sources. I can go back and I can understand exactly what happened. Whereas the quote-unquote United States, the District of Columbia, was created and recreated is probably the better term. And we're dealing again with sort of a copy without an original. The United States being sort of a declaration of Congress. It's a little strange to think of it this way. Congress, in fact, recreated Congress. Why do we call Congress, when Congress assembles, of course, they're called Congress assembled. They're representing the states. But we also have the United States, where Congress assembled, created Title II of U.S. Code, which is called Congress. So Congress created Congress of the United States. And so they basically created themselves a job. They created themselves a membership to this corporate structure that we're going to be talking about. Now, a lot of people have had problems with the notion of accepting or even like verifying. I don't know, people don't seem to be able to verify for themselves certain things, which, you know, okay. Let's confirm today the notion of the corporation, right? My whole gig, my whole background was called the corporation nation. What is the corporation nation? Why do I keep saying the corporation, that the state is a corporation, that the cities, the counties, the districts, they're all corporations? Why does he keep saying that? I don't understand. Well, because they're corporations. Let's let's go to the source, because I don't want you to believe what Clint Richardson says. I want you to believe what the congressional record actually says. So this is going to be part of my second book, a very large section on different court cases that explains all of this in very great detail. The question is, do you understand? Do you understand that you're run by corporations? That after the Civil War, the corporation was created, sort of a holding company, if you will, for the property of the United States or Congress. So Congress, everything in the United States is property of Congress, a creation of Congress. It is not a creation of the quote-unquote state. In other words, the Union itself was a compact between the states, but the United States as an entity is a separate corporate structure. So again, don't believe me just because I say it's true. Believe believe the comprehensive annual financial reports that you can pull up for your city, your county, your school district, your state, where it says on the first page, on the actual seal of every city and state and county, incorporated, whatever, 1848, incorporated on this date. You can't really argue with that. However, some still do. So let's read. Let's just read, okay? Let's go back to, I don't know, what year are we in here? Gosh, let me verify the year before I start this long diatribe on this case. Let me make sure I've got the correct year here. This was the Metropolitan Railroad Company versus the District of Columbia. Decided October 21st, 1889, 132 U.S. 110 SCT 1933 L, edition 231. Nathaniel Wilson and Walter D. Davidge for the plaintiff in error, A.G. Riddle and H.E. Davis for the defendant in error, etc., etc. So it's a legitimately recorded court case, which I copied over, and it explains exactly what happens. Now, the petitioner in this case is District of Columbia, a municipal corporation. Okay, let me say that again. District of Columbia, a municipal corporation petitioner versus Ocean Risk Retention Group, Inc. Okay, now, so here the petitioner is the municipal corporation of the District of Columbia. Now, okay, if that's still not enough for you, let's go into the entirety of the case so that we're clear and we understand what happened, how the United States what we think of the United States was sort of just incorporated and thrown into this district. Let's see how it works. Sections 1 and 18 of the Act of Congress of February 21st, 1871. Remember, this is after the Civil War, post-Civil War. Entitled, An Act to Provide a Government for the District of Columbia, 16 Statute 419, are as follows. Section 1, that part of the territory of the United States, including within the limits of the District of Columbia, be, and the same is hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal, and exercise all other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States and the provision of this act. Notice here, it may have a seal. Okay, so it's a person, a corporation. United States is a person, just like the Vatican or the Holy See is a person. All right, the king these are persons. We're talking about corporations. And it may have a seal. What is the seal? Remember, the seal is defined as the arms of the United States. It's flag and seal. All right, so it can contract, it can be sued, and it can sue and be sued. It can plea, which is of course what the attorney general does, etc., etc. Right, so it's a person. Corporations are persons too. Remember? So, okay, all the other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States and the provisions of this act. Section 18, and we're still in the Act of 1871. Okay, this is all going to change. Extend the legislative power of the district shall extend to all rightful subjects of legislation within the district, rightful subjects, that's you, of legislation within said district, consistent with the Constitution of the United States and the provisions of this act, subject nevertheless to the restrictions and limitations imposed upon states by the 10th section of the first article of the Constitution of the United States. But all acts of the Legislative Assembly shall at all times be subject to repeal or modification by the Congress of the United States, and nothing herein shall be construed to deprive Congress of the power of legislation over said district in as ample manner as if this law had not been enacted. These sections are carried forward into the Act of Congress of June 22nd, 1874, entitled An Act to Revise and Consolidate the Statutes of the United States, General and Permanent in their nature, relating to the District of Columbia, in force on the first day of December in the year of our Lord, 1873, etc. Okay, now listen up, folks, because it's now going to say "and whereas," which essentially means because the reason for stating these facts becomes clear when you read the rest of the case, right? So it's telling you what it's going to do and why it's going to do it. So it's going to state the history, it's going to state the facts. And so it says, and whereas the Constitution does provide that Congress has the power to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by session of particular states and the exception of Congress, become the seat of government of the United States. A municipal corporation became the seat of government of the United States. It is completely a creation and in control of the Congress. Okay, so, and whereas on February 21st, 1871, the 41st Congress passed an act entitled, quote, an act to provide a government for the District of Columbia, as we just read, legislating the organization of a municipal corporation to run the day-to-day affairs of the District of Columbia, the seat of government, which transferred, now listen, which transferred the United States of America, the Republic, into a corporate entity entitled United States. Not the United States, but United States. In capital letters, having no jurisdiction outside the District of Columbia. Did you hear that, folks? Which transferred a municipal corporation, legislating the organization of a municipal corporation to run the day-to-day affairs of the District of Columbia, the seat of government, which transferred the United States of America, the Republic, into a corporate entity entitled United States, having no jurisdiction outside of the District of Columbia. What are you a citizen of? Are you a citizen of California, Nevada, New York, or are you a citizen of the United States? Where then do you exist? Do you exist in Nevada? No, you exist in the United States. And whereas Congress adopted the text of the federal Constitution as the Constitution or charter of this municipal corporation, this municipal corporation was granted the power to contract to provide municipal services to the inhabitants of the District of Columbia, and necessarily as an operation of the Privileges and Immunity Clause of the Article 4 of the Constitution. Any other person who chooses to contract for its services. I'm going to read that again. They adopted the Constitution as their charter. Okay, this municipal corporation was thus granted the power to contract. A person is granted, a corporation granted the power to contract to provide municipal services, just like you get from your regular cities, states, counties that you live in, to the inhabitants of the District of Columbia. That's you. Well, actually, that's not you. Excuse me. You're not inhabiting there. And necessarily as an operation of the Privileges and Immunity Clause of the Article 4 of the Constitution, any other person who chooses to contract for its services. That is you. Those who live in the district are not the same as any other person who chooses to contract for its services. So what have we learned? The United States of America, what you think it was, whatever you possible romanticized version of what you think it was incorporated. It was enfranchised into the District of Columbia, a municipal corporation. Its charter became a copy of the United States Constitution. And we are all contracted into it unknowingly through the birth process, which is all that we've explained in past shows. Okay. Now, again, this is not Clint Richardson saying this. This is not some twisted history in some ethics class or something. No, this is straight from the record. And we're going to keep going here. It is contended by the plaintiff that it, quote unquote, the District of Columbia, that is, so we're reading from the other case now, is not amenable to the statute of limitations for three reasons. First, because of its dignity as partaking of the sovereign power of government. Secondly, because it is not embraced in the terms of the statute of limitations in force in the district. And thirdly, because if the general words of the statute are sufficiently broad to include the district, still municipal corporations, unless specifically mentioned, are not subject to the particular statute that is at bar in this case. All right. The first point is what we should be focusing on. This is not just any municipal corporation. It enjoys the dignity of partaking of the sovereign power of government. Okay. The first question, therefore, will be whether the District of Columbia is or is not a municipal body merely, or whether it has such a sovereign character or is so identified with or representative of the sovereignty of the United States as to be entitled to the prerogatives and exemptions of sovereignty. See, the thing about sovereignty, folks, and I know that a lot of people believe that they can indeed be sovereign. Sovereignty requires two things. First of all, sovereignty is lawlessness, okay? A lawmaker is lawless. You don't have to follow your own laws. Secondly, you have to rule over people to be sovereign. You must rule over others to be sovereign. Okay, no man is sovereign. The Pope, that's an office. The President, that's an office. The Queen, the King, those are offices of the corporation. Okay, no man is sovereign. Only the corporation is sovereign. We worship artificial persons. That's the whole point. That's the whole reveal. We have taken false gods. It's simple as that. And we're warned about that and what will happen to us. In order to get a better understanding of the subject under consideration, it will be proper to take a brief survey of the government of the district and the changes it has undergone since its first organization. Well, that's kind of you to tell us that. Thank you. Prior to 1871, the local government of the District of Columbia on the east side of the Potomac had been divided between the corporations of Washington and Georgetown, and the levy court of the county of Washington, excuse me. Georgetown had been incorporated. Oh, no, they're not corporations. Georgetown had been incorporated by the legislature of Maryland as early as 1789. That's under Davis, the laws of D.C. 478. As Alexandria had been by the legislature of Virginia. Again, Alexandria was incorporated by the legislature of Virginia as early as 1748, 1779. And those towns or cities were clearly nothing more than ordinary municipal corporations with the usual powers of such corporations, i.e. persons at law. When the government of the United States took possession of the district in December 1800, it was divided by Congress into two counties, that of Alexandria on the west side of the Potomac and that of Washington on the east side, and the laws of Virginia were continued over the former and the laws of Maryland over the later, and a court called the Circuit Court of the District of Columbia was established, with general jurisdiction, civil and criminal, to hold sessions alternatively in each county. But the corporate rights of the cities of Alexandria and Georgetown, those municipal corporations, their corporate rights, and of all other corporate bodies, in other words, all other cities, counties, states, etc., were expressly left unimpaired, except as related to judicial powers. See the Act of February 27th, 1801, which is 2 Statute 103. A supplementary act passed a few days later gave to the circuit court certain administrative powers. There's that horrible word, to administrate something. You only administrate what you create. The same as those vested in the county and levy courts of Virginia and Maryland, respectively, and it was declared that the magistrates, remember what magistrates means, gods. Okay, look it up. Webster's 1828 or, probably any dictionary. And it was declared that the magistrates to be appointed, the gods to be appointed, should be a board of commissioners within their respective counties and have the same powers and perform the same duties as the levy courts of Maryland. These powers related to the construction and repair of roads, bridges, ferries, care of the poor, etc., just, like any other municipal corporation. On May 3rd, 1802, an act was passed to incorporate the city of Washington. No, I insist, it's not a corporation. Please, it's not a corporate nation. No, yes, it is. Here's your proof. On May 3rd, 1802, an act was passed to incorporate the city of Washington, 2 Statute 195. It invested the mayor and common council, the later being elected by the white male inhabitants. Oh, there it is, the white persons, right? Because that's all that could vote. Don't forget that. That's the nature of this country. With all the usual powers of municipal bodies, such as the power to pass bylaws and ordinances, powers of administration, regulation, and taxation, among others, specially named, the power to erect and repair bridges, to keep and repair all necessary streets, avenues, drains, and sewers, and to pass regulations necessary for the preservation of the same, agreeable to the plan of the said city. Now, that is just like any other municipal corporation. Whatever city you live in, those are your taxes right there. Your sewer, your streets, your bridges. There's always a bridge fund or some other kind of fund that they're sticking money into to take it out of the general fund, right? And so at this point, what we're talking about is a normal, average municipal corporation. Because remember, we're still well before the Civil War happened, before the United States was debunked, was separate, before Congress abandoned Congress assembled, i.e. the States United, right? So we're well before that. So here is a municipal corporation like any other that was created to take care of the local area, again, 10 miles square. So various amendments from time to time were made to this charter, and additional powers were, of course, conferred. A general revision of it was made by the Act of Congress passed May 15th, 1820. That's 3 Statute 853 or 583, excuse me. A further revision was made and additional powers were given by the Act of May 17th, 1848, still before the Civil War, 9 Statute 223. But nothing to change. Nothing changed. So telling you right here, nothing happened in all of this, all these additional conferred powers, nothing to change the essential character of the corporation. I'm not saying that. That is what it says. Nothing to change the essential character of the corporation. The powers of the levy court extended more particularly to the country, aside of the cities, outside of the cities, but also to some matters in the cities common to the whole county, and it was recognized and its powers and duties more specifically defined in the acts. Again, at this point, it's still just a regular city or i.e. municipal corporation, a district in this case. The acts of July 1st, 1812, etc., March 3rd, 1863, which is 12 Statute 799. By the last act, the members of the court were to be 9 in number and to be appointed by the President and Senate. So what do we have here? We have the beginning of what? The Supreme Court, maybe? In the first year, okay, so here we get to the Civil War. In the first year of the Civil War, I want you to remember that, who was it that said, I can't remember who said this, but I have the quote, and it was simple. It was, a civil war is a war of words. A civil war is a war of words. In the first year of the Civil War, August 6th, 1861, which is 12 Statute 320, an act was passed to create a metropolitan police district of the District of Columbia and to establish a police therefore. The police had previously been appointed and regulated by the mayor and common council of Washington, but it was now deemed important that it should be under the control of the government. An act provided for the appointment of 5 commissioners by the President and Senate, who, together with the mayors of Washington and Georgetown, were to form the Board of Police for the district. And this board was invested with extraordinary powers of surveillance and guardianship of the peace. This general... Now, you got to understand something else here. The word police, if I go in and I look in the old dictionaries, there were no police officers. There were no guys walking around as we have today. That is a purely modern notion of what police is. When we look up the word police, it comes from the word politia or city. Okay, it's the government of a city or town. So they're not necessarily talking about just an organized street gang that we now call police that get away with murder. No, they're talking about the government itself, the government of a city or town, the administration of the laws and regulations of a city or incorporated town or borough. This is from 1828, Webster's Dictionary. Okay, as the police of London, New York, or Boston. The word is applied also to the government of all towns in New England, which are made corporations by general statute for certain purposes. Oh, but they're not corporations. It's not a corporation nation. The internal regulation and government of a kingdom or state is the police, the politia. The corporation or body of men governing a city. In Scottish, the pleasure ground about a gentleman's seat. In other words, your landholder, right? So the pleasure ground, they called it. Fucking disgusting. So again, what we see here is the municipal corporation starting to be changed into something other than just a municipal corporation like any other city. Suddenly, it's starting to get sort of a more governmental feel, a body politic, etc. In the first year of the Civil War, again, the established police, the act provided for the appointment of 5 commissioners. Wait, what's a commissioner? That's not a policeman. That's not a cop walking the beat. By the president and Senate, who, together with the mayors of Washington and Georgetown, were to form the board of police for the district. And this board was invested with extraordinary powers of surveillance and guardianship over the peace. In other words, the commissioners, right? There used to be a show called The Commish, and he was in charge of all the police. The police, when they finally did come around, were basically thugs. They were hired. They're basically hired criminals. I mean, that is it's basically the government of a town understanding that they have no power, and the only way to really have power is to have a goon squad, right? So the police officers then started showing up way later. This general review of the form of government which prevailed in the District of Columbia and the city of Washington prior to 1871 is sufficient to show that it was strictly municipal in its character, okay, before government fell apart, before the Civil War happened, and that the government of the United States, except so far as the protection of its own public buildings and property was concerned, took no part in the local government any more than any state government interferes with the municipal administration of its cities. All right, so in other words, Washington, D.C. was not the United States. Do you understand? There was no United States seated in the District of Columbia. It was a municipal corporation not called the United States. The United States was considered as when Congress, as representatives, delegates, if you will, of the states, got together and assembled and made legitimate laws that were constitutional. And all that means is that they followed the negative aspect of the Constitution. They didn't mess with they only did, in other words, what they were allowed to do. They didn't try to go against the Bill of Rights, etc., etc. Okay, but that changed, obviously, and that's what it's trying to tell you here. Because we're trying to decide in this case, which is after 1871, what the United States now is, because it's claiming to have sovereignty, which any municipal corporation does not have. It is under the sovereign. The state is the city's sovereign, basically. So the officers of the departments, even the president himself, exercise no local authority in city affairs. It is true, in consequence of the large property interests of the United States in Washington, in the public parks and buildings, the government always made some contribution to the finances of the city, but the residue was raised by taxing the inhabitants of the city and district, just as the inhabitants of all municipal bodies are taxed. Okay, now it's going to tell you exactly what happened, how everything changed, how your romantic version of the United States got turned into a corporation. In 1871, an important modification was made in the form of the district government. A legislature was established within, with all the apparatus of a distinct government. Now, do you understand why? Well, that's because the government was defunct. The Civil War happened. The president there was no war declared. It was the first use by Lincoln of the Declaration of Emergency, which is essentially a declaration of war against the emergency. What's the emergency? Well, certain states want to leave the Union because of its corruption, because of its money, and the control the money has over it, and, of course, because they wanted those southern states, the new states especially, to pledge all of their lands and properties towards the debt of the United States. You see, they still had war debts. Now, of course, those newer states said, "Wait, we're not, we're on equal footing with the original states, but we're not going to sign ourselves up to be responsible for the debt. No, we're trying to escape debt." In 1871, an important modification was made in the form of the district government. Legislature was established with all the apparatus of a distinct government by the act of February 21st of that year, entitled An Act to Provide a Government for the District of Columbia, which is 16 Statute 419. It was enacted in Section 1 that all that part of the territory of the United States included within the limits of the District of Columbia be created into a government by the name of the District of Columbia, by which name it was constituted a body corporate for municipal purposes, with power to make contracts, sue and be sued, and to exercise all other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States. A governor and a legislature were created. Also a board of public works, the latter to consist of the governor as its president, and 4 other persons to be appointed by the president and Senate. So all of a sudden, this plain, ordinary, quote-unquote, district or city as a municipal corporation becomes a kind of a government of its own. It became a body corporate for municipal purposes with the power to do all these things. Wait a minute, what's going on here? Suddenly a new monster has emerged. We don't really understand what it's going to become quite yet, but obviously they've got plans, don't they? You see, they incrementally build this thing. It's all about incrementalism, right? You don't do things just overnight. You do them over the years. New generations don't know what the last generation knew. They won't listen to the warnings of the previous generations. And new bills are passed, new acts, right? These are all different acts that are happening that recreate what is already created, right? Morph it, evolve it or de-evolve it, depending on your purpose. So all of a sudden, we have something new. Let's see. To this board was given. So you have now a board of 6 people who, and a governor, its president, to be appointed by the president and the Senate. To this board was given the control and repair of the streets, avenues, alleys, and sewers of the city of Washington, and all other works which might be entrusted to their charge by the Legislative Assembly or Congress. They were empowered to disperse the monies raised for the improvement of streets, etc., and to assess upon adjoining property specifically benefited thereby. It goes on with all that stuff that a district would do. Now, the difference here is that while before you had Washington, D.C. located in 2 different counties of 2 different states, what they did here was they made it into its own quote-unquote district. So it is no longer a part of any state. It is now completely external from any state. It is therefore a foreign corporation to all states, all other municipal corporations, etc. Therefore, any commerce that is done between the United States and any other entity is now foreign or quote-unquote interstate commerce. So all citizens, in other words, of the United States, when they do commerce in any of the states, they're foreign in their nature. They're an agency. The state is a third party, and through that agency, they conduct the business of their master, which is the United States, their principal, their employer. So, yeah, everything you do, therefore, is interstate commerce and taxed. This is why it's so important in the Constitution that the United States be in control of commerce, interstate commerce, foreign commerce. Let's see. Let me skip to some interesting stuff here because it's a really boring treatise in some of these parts. The Constitution. Let's see. Mississippi Barnes, District of Columbia. It was regarded as a mere branch of the district government, though appointed by the president and not subject to the control of the district authorities. This Constitution lasted until June 20th, 1874, when an act was passed entitled An Act for the Government of the District of Columbia and for other purposes. Wow. It's suddenly a government. It's no longer just a corporate structure for municipal purposes. It's now a government. What? That's 18 Statute 116. By this act, the government established by the act and the president, by and with the advice and consent of the Senate, was authorized to appoint a commission consisting of 3 persons to exercise the power and authority then vested in the governor and board of public works, except as afterwards limited by the act. By a subsequent act approved June 11th, 1878, 20 Statute 102, it was enacted that the District of Columbia should remain and continue a municipal corporation as provided in Section 2 of the revised statutes relating to said district, etc., etc., etc. All rights of action and suits for the district were expressly preserved in statu quo under these different changes. The administration of the affairs of the District of Columbia and the City of Washington had gone on in much the same way, except the change in the depositories of power and the extent and number of powers conferred upon them. Legislative powers have now ceased, and the municipal government is confined to mere administration. The identity of corporate existence is continued. I am a person called Washington, D.C., and all actions and suits for and against the district are preserved unaffected by the changes that have occurred. In view of these laws, the counsel of the plaintiff contend that the government of the District of Columbia is a department of the United States government, and that the corporation is a mere name and not a person in the sense of the law, distinct from the government itself. However, the court says, we cannot assent to this view, the view of the plaintiff. It is contrary to the express language of the statutes. The language is that the district shall remain and continue a municipal corporation, with all rights of action and suits for and against it. If it were a department of the government, how could it be sued? Because government is sovereign, right? Can the Treasury Department be sued or any other department? We are of the opinion that the corporate capacity and corporate liabilities of the District of Columbia remain as before, and that its character as a mere municipal corporation has not been changed. The mode of appointing its officers does not abrogate its character as a municipal body politic. We do not suppose that it is necessary to a municipal government or to a municipal responsibility that the officers should be elected by the people. Local self-government is undoubtedly desirable where there are not forcible reasons against its exercise, but it is not required by any inexorable principle. All municipal governments are but agencies of the superior power of the state or government by which they are constituted. Remember who created the United States? Congress. The Congress assembled, which is called the United States of America. The United States of America doesn't exist as anything tangible. The United States of America exists as Congress assembled, all the representatives of the states getting together and assembling. That's it. It's a I won't say it's a metaphor. It's a title. It's a nothingness. It's a corporation. Oh, again, all municipal governments are but agencies of the superior power of the state or government by which they are constituted and are invested with only such subordinate powers of local legislation and control as the superior legislature sees fit to confer upon them. The form of those agencies and the mode of appointing officials to execute them are matters of legislative discretion. What was created, folks? A municipal corporation, a holding company, basically, for all of the United States properties, its public properties, including its citizens, including the men who contract with it. It is still a municipal corporation. But you see, a municipal corporation has power over its inhabitants, its contracted citizens. So again, this is the trap we have fallen into. We believe that we are in, quote unquote, the United States of America, in the geographical sense. That's where we exist. But we forget that our status only exists in, quote, United States. Not the United States, but, quote, the corporation called United States, the seat of government located in the municipal corporation called Washington, D.C. See, this is the big trick. Because the jurisdiction of Washington, D.C., i.e. the United States, extends over all public lands and extends as the Constitution over all the states, we have been sort of tricked, if you will, into thinking that we are all living in the geographical area of the United States. But in fact, the geographical area of the United States, a corporation, is 10 miles square. And it's actually less than that. All right. So we're operating as foreign entities in the states where we reside. It's not so hard to understand this. It's hard to accept, even though there's telling you, this is how it works, and this is what is happening. That Washington, D.C. is a municipal corporation where the seat of government was placed. Again, what did it say above? It said the United States of America was incorporated into Washington, D.C. It's an agency of Congress, right? It's an agency of the United States, which is Congress assembled. It's their creation. It is not the free, as they say, republic, etc. of the states united. It's not the territory that we're all from. No, it's not the land. It's a corporation. It's no part of the land. The law of the land means law of the sea. Oh man, I gotta tell you, once you get it, once you see it, once you see again, what we're talking about here is history, real history, the kind of history that was made into law, the kind of history that cannot be denied. Right? I can say that the senator who passed this particular bill was wearing a very fine suit and tie and was there on Christmas night, late at night, and passing. Oh, and they sneaked the bill through and they created this. But all that really matters is what's written in black and white, which is what I'm reading to you. I'm not giving you my opinion here. I'm not telling you that you should believe in my history, my version of history, whether I'm a victor or a loser. No, I'm reading straight from the books here. All right? You want to deny that the United States is a corporation? You want to deny that every city and state and county and district is a corporation? A person at law with the right to sue and be sued, etc.? I don't know what to tell you. That kind of denial, when the facts are right in front of your face, that's bordering again on this nihilism, this notion of nothing exists, nothing, to deny existence, to deny what is written in black and white. Okay, now I understand absolutely the notion that yes, none of this exists in nature. I say that all the time, but I'm not saying it doesn't exist. I'm just saying it's not part of God. It's not part of nature. Right? Don't get those two concepts confused. I'm not going to, as a citizen of the United States, I'm not going to pretend that the United States doesn't exist. That would be foolish. And yet that's what a lot of these guys do out there. It's absolutely foolish. I don't know any other way to put it. It's a non sequitur, a non-starter. I'm a citizen of the United States, yet the United States doesn't exist. Well, it does exist as a fiction. And fictions are perfectly, quote unquote, legal. Right? Remember, it all boils back down to volunteerism. You volunteer to be part of this, to be in the United States, not in the States United. In other words, a corporate entity. So, all municipal governments are but agencies of the superior power of the state or government by which they are constituted. Remember, the Constitution was established as its charter, right? So, again, controlled by Congress, and are invested with only such subordinate powers of local legislation and control as the superior legislature, Congress, sees fit to confer upon them. The form of those agencies and the mode of appointing officials to execute them are matters of legislative discretion. Commissioners are not unfrequently appointed by the legislature or executive of a state for the administration of municipal affairs, or some portion thereof, etc., etc. Let's see. Boldness of corruption, the absence of public order, or necessity of high. It may be demanded by motives of expediency or the exigencies of the situation, by the boldness of corruption, the absence of public order and security, i.e. anarchy, or the necessity of high executive ability in dealing with particular populations. And it's what it's talking about here is let's see. Such unusual constitutions do not release the people from the duty of obedience or from taxation, or the municipal body from those liabilities to which such bodies are ordinarily subject. Protection. So in other words, just because this United States was recreated into its own corporate structure outside of any state, its own territory, its own land, does not mean that it doesn't have obedience and tax and doesn't still belong to Congress, in other words. Protection of life and property are enjoyed, etc. And the government of the whole people is preserved in the legislative representation of the state or general government, nor can it in principle, said Mr. Justice Hunt in the Barnes case, be of the slightest consequences by what means these several offices are placed in their position, whether they are elected by the people of the municipality or appointed by the president or governor. Now, I want you to remember, folks, that 99.999% of the federal government are appointed. I don't know if you ever stop and think about this. You elect a president, and that president then appoints all his cabinet. That president appoints basically the vice president, although you vote on the vice president. Not that you can actually say, I want the president, but not the vice president. So it's not really a vote. And all you're really doing when you vote is saying yes to one of the family members. So whether it's Democrat or Republican, the same bloodline. Doesn't matter. A vote yes is basically a vote for tyranny. A vote no is essentially a vote yes. A no vote. If you don't vote at all, you're still voting yes. You're just remaining silent, which is probably the greatest crime in history is silence. When we go on, it goes on in the cases where the question was whether a citizen of the district could sue in the circuit courts of the United States as a citizen of a state. The court did not deny that the District of Columbia is a state, colloquially that is, in the sense of being a distinct political community, but held that the word state in the Constitution, where it extends the judicial power to cases between citizens of the several states, refers to the states of the Union. So when we say that the government is the state, that the federal government is the state, we're actually misspeaking. We're not saying the wrong words, but we're using the same word as what an actual state is, and we're very mistaken in that regard. Because remember, a U.S. citizen is not a citizen of any state. In the notion of any of the several, which means private or foreign states. the states of the Union. It is undoubtedly true that the District of Columbia is a separate political community in a certain sense, and in that sense may be called a state. But the sovereign power of this qualified state is not lodged in the corporation of the District of Columbia, but in the government of the United States. Where is the government of the United States seated? In the municipal corporation of Washington, D.C. Does that mean Washington, D.C. itself is sovereign? No. It's a creation of the government of the United States, which happens to be located in its municipal corporation. In other words, they created a foreign corporation. They created an offshore, if you will, corporation to operate all of their criminal organized activity. It's a pirate cove. It's all this means, right? And it's not romantic. It's not a good history. It's not anything good. This is the monster that was created and where all of our complaints come from, even as we wave its flag. In a certain sense, it may be called the state, but the sovereign power remains in the government. Subordinate legislative powers of a municipal character which have been or may be lodged in the city corporations or in the district corporation, do not make those bodies sovereign. Crimes committed in the district are not crimes against the district, but against the United States. Crimes committed in the district are not crimes against the district, but against the United States. It's a little confusing, doesn't it? Therefore, while the district may, in a sense, be called a state, it is such in a very qualified sense, not to be compared to the other states. It was held that parties residing in one county could not be said to be beyond the seas or in different jurisdiction when it was still part of two counties in reference to the other county. They were in Washington, D.C., no matter which county they were in or which state. We're clearly of the opinion that the plaintiff is a municipal corporation. The plaintiff is a corporation. So what was the name of the case? All right, the District of Columbia, a municipal corporation. So we are clearly of the opinion that the plaintiff is a municipal corporation having a right to sue and be sued and subject to the ordinary rules that govern the law of procedure between private persons. So a corporation is in court claiming that it has the rights of any other person, private person. All right. Now, I don't know what to say, folks. Again, this is why I say the corporation nation. It's the tagline of my entire first 7 or so years of research, movie making, etc. Right? I can't be any more clear than I am in reading directly from the law, the legislative enactments that were created. I can't be any more clear. If you still can't quite grasp this, which I understand, it's very confusing because we're talking about fiction. You're talking about a corporation that doesn't exist in nature, claiming that it's a person, which is a status in society, and that the corporation as a person, just like your rights are listed in Title 42. That you have the right to sue and be sued, etc. That's your right as well as a person. But we forget, you see, that Washington, D.C. is a person too. Corporations are persons too. Because we live in fiction. We respect persons. What does the Bible say over and over and over? Do not respect the persons of men. Do not respect persons. Do not respect flattering titles that are conferred upon persons, because you can't hold a flattering title unless you have a status already, a person. And in fact, that's exactly what it says. It continues. It says corporations are persons in the law. See, when you say in the law, that's like saying in the cartoon, Bugs Bunny really is a bunny. In the cartoon, when Wile E. Coyote falls, he really falls and goes boom, and a rock falls upon him, and somehow he lives. These things are true in the cartoon, just like corporations are persons in the law. It's fiction, but we respect it. We respect persons, therefore, corporations are persons. There is no apparent reason why they should not be included in the statute in question. It is conceded that private corporations are included. On what ground, then, can municipal corporations be excluded? Not on the ground that they are not persons, for that would exclude private corporations as well. They are therefore within the terms of the law, i.e., they can be sued and they can sue. Federal Reserve. Did you know that you can sue the Federal Reserve? Do you know that in its comprehensive annual financial report, it lists all the lawsuits against it, just like every other municipal corporation does, because it's a person that can sue and be sued? Oh, but you don't even know what the CAFR is, do you? Or maybe you've heard of it. Maybe you've heard around the way that there's some mysterious double set of books or whatever. Yeah, you see, there's a whole thing going on that most people have no idea what's happening. Governmental and non-governmental functions of government. See, the United States was created specifically for non-governmental issues, things of commerce. You look at the code, the U.S. Code of the United States, it's divided up into prima facie law, in other words, not official law, unwritten law, and statutory law. And you find that everything commercial is prima facie. Everything that is reasonable is, of course, under the statutory, the approved laws, the legitimate laws, if you will. And so again, here it says right here, corporations are persons in the law. They should be included in the statute because they can sue and be sued. They don't have the sovereignty. The actual municipal corporation does not have the sovereignty of the United States. Again, the United States is seated within. It's very important to remember that this United States, this municipal corporation, is outside of any state. That's why we call it colloquially a state, even though that's an incorrect description when comparing it to other states. But you got to remember, this thing is a foreign entity. It is not within any of the states. Remember those states that its counties were sharing parts of the United States. They ceded those lands to the United States. So again, we're talking about a completely foreign entity. I can't stress the importance of this enough. The United States, District of Columbia, is a completely foreign entity to the United States of America. Again, remember, the United States is a corporation inside of the United States of America, or I should say under its sovereignty, under its jurisdiction, under the jurisdiction of Congress, in other words. Congress assembled is the United States of America. It's not the states themselves. It's Congress assembled. All right, so that's the higher power, the higher level. And that's why if you approach the United States from that sort of outside tier where common law and everything else is, then you actually find might not know what you're doing, but you actually have some luck, some you might actually get something done. But if you are still acting from within that circle that the United States, that district that the United States is holding, including your citizenship, your person, well, then you're kind of screwed. You do what it says. But if you can figure out how to operate outside of that, because you got to remember that Congress, it is the sovereign over the United States and over that district. So, you got to figure out how to be higher or operate within the common law, etc. Now, again, I'm not a promoter of common law. Common law is also all the judges' decisions, all the court cases. which we call case law. I'm not a big fan of attorneys in black muumuus myself. I don't believe that they should be lawmakers, you know? Just my thing. I've got a lawmaker. So it's so important to get the notion that this is a foreign private entity. And you could say, therefore, that it's a private corporation, etc., but that gets real hairy. It gets confusing. So private means foreign, and this is why all states are foreign to each other, and the United States corporation is foreign to all states and nations. Private corporations are also persons, so why should not a municipal corporation? Why should municipal corporations be excluded from being corporations? They're corporations, they're persons, and they have the right to be sued and sue as a person. Not on the ground that they are not persons, for that would exclude private corporations. They are therefore within the terms of the law. And we continue. Are they not also within the spirit and reason of the law? They're certainly within the reason of the preamble. It is just as much for the public interest and tranquility that municipal corporations should be limited in the time of bringing suits as that individuals or private corporations should be. The reason stated in the preamble for the passage of the law applies to all, and moreover, it shows that the objects of the law are beneficial ones, and therefore that it should be liberally construed. It cannot apply to the sovereign power, of course. No restrictive laws apply to the sovereign unless so expressed. Again, sovereignty is lawlessness, with the exception of those laws that it was set up to agree or that Congress passes. So although you can sue the District of Columbia as a municipal corporation, the seat of government within it, hiding there like a freaking pirate cove, like I said, you can't touch it unless they have a law that says you can. Nope, but you can sue the corporation. And of course, whatever Congress sets up inside of its holding corporation, when it creates new entities like the Federal Reserve, etc., it sets it up in the United States as a foreign corporation inside the District of Columbia, inside that seat of government, and it creates it as a person, a corporation. Again, this is why you can sue all these different governmental agencies. Because they're persons, they're corporations, they're artificial persons. And this is what we worship. I can't stress this enough. Whatever the United States was in history, whatever romanticized version you had, that is not what we're dealing with anymore. We are inside of this corporate structure. We, when I say we, I mean United States citizens, the public, anything published. Remember, you're a published person, right? So, especially no laws affecting a right on the ground of neglect or leeches, because neglect and leeches cannot be imputed onto him, and it matters not whether the sovereign be an individual monarch or a republic or a state. The principle applies to all sovereigns. Sovereigns are untouchable, my friends. They're lawless. The reason usually assigned for this prerogative is that the sovereign is not answerable for the delinquencies of his agents. The sovereign is not answerable for the delinquencies of his agents. Remember what you are? Remember that you're an agent. You are the agent for service of process for the person. You deal with third parties. Your principal government, your principal employer, your principal trustor is the United States, or i.e., quote, United States, the corporation.
No, it's not a corporation. It can't be a corporation. It's romantic. It was started by lovely fathers. It can't be a corporation.
Well, okay. Whether the true reason may be, Such is the general law, such is the universal law, except where it is expressly waived. So it's so kind of the sovereign to waive its powers, its lawlessness. The privilege, however, is a prerogative one and cannot be challenged by any person inferior to the sovereign, whether that be a person be natural or corporate. Remember, they call you a natural person. That doesn't mean it's speaking of nature. It's just referring to a natural person as an individual. One man acting in a persona, in a status. It does not refer to anything in nature. Please understand that. Remember, legalism is always opposed to nature. So you cannot say that the word natural means it grew in nature. And this is why on any product you buy from the store, it can say, we're 100% natural. But wait a minute. What is this long scientific name that you've created in some lab? How is that natural? Well, it's legally natural. It doesn't mean it's actually from nature. It's legal. It's been legalized to be natural. You see, that's how it works. That's how anything can be made, quote unquote, lawful. You just have to legalize it. You just have to say the name and control the name and regulate and administer the name. It is scarcely necessary to discuss further the question of the applicability of the statute of limitations to a purely municipal corporation when it is embraced within the general terms of the law. It was expressly decided to be applicable in many, many cases that are listed here. In the section cited, accurately says, the doctrine is well understood that the sovereign power of the maxim applies, which is nullum tempus occurrit regi, and that the United States and the several states are not, without express words, bound by statutes of limitation. Let me say that again. The United States and the several states are not, in their sovereign capacity, bound by statutes of limitation. That's sovereignty, but you get it? There's no law. Although municipal corporations are considered as public agencies exercising, in behalf of the state, public duties, there are many cases which hold that such corporations are not exempt from the operation of limitation statutes. So, as a municipal corporation, again, is bound by certain statutes of limitations, but the United States, hiding out within it, the seat of government that they created, that corporation, where what did it say? They transferred the United States of America into that corporate structure to be administered corporately, in other words, commercially. Okay, so that is not exempt, or that is exempt, excuse me. But such statutes, at least as respects all real and personal actions, run in favor of and against these corporations in the same manner and to the same extent as against natural persons. What this is trying to tell the plaintiff here is that, or anyone out there that's reading this, is look, when you are dealing with a municipal court, when you're dealing with your city, your county, your school district, I want you to listen closely to this, folks. When you are dealing with the corporation that is your city, your county, your state, your school district, or any other district, you do not go and speak to one of its uneducated, idiotic representatives. Okay, they're not a party to all of this information. They're there as any other employee of any other corporation. They're going to always be on the corporation's side. The problem that you all have out there is that you are not treating all persons equal. What do you think you should be treating your city as? A person that can sue and be sued. Why do you treat a city as anything different than any other person, corporation, individual, association? Why would you treat any city at all, any state, any county, any differently than any other person that you see out there. Because remember, we're all equal. See, that's what it's trying to tell you here. You got it wrong. You're thinking of a city in some romantic fashion. It's just a person. It's just a person that can sue and be sued and be held liable for damages just like any other status, any other person. Why do you treat it differently? Why do you believe that when you go and you get told no or piss off or you get treated so badly by some representative, some agent of the agency that is the city, why do you think that that is the end-all be-all of your interaction with such a person? Right? The representative is not the person. Representative is just an idiotic employee. Do you think that your journey, your possibilities with the city ends at some jerk that's been working for 20 years and just wants his pension? No. No. You see, anytime you're dealing with a person, your court should be the mail. The mail system is set up exactly for that. That's why you're never going to see an end to the mail system, no matter how incredibly advanced the computers get, how incredibly advanced emails get. You have to have a post office. You have to have something that delivers something to your address because you are the registered agent for service of process. That cannot be done, at least at this point, digitally, unless we agree to that. You have to have an address. You have to be able to be served. The police have to be able to protect and serve you summons and protect the municipal corporation that it's an employee of. Remember what police are. Police are government. They're not what you think they are. So, I again, we have to change our perspective. If we're going to operate in the commercial system, then you better start treating everything as a commercial entity or person, an agency, whatever. And you better know the difference between what is sovereign and what is not, because there's only one entity that is sovereign. Everything you deal with on a daily basis is not. It's something that you contract with. It's a person. Do not respect persons. Do you know that's written in the Bible at least 100 times? Every chapter almost. That the statute, in the same manner and to the same extent as against natural persons, that the statute of limitations runs against a county or other municipal corporation, we think cannot be doubted. The prerogative is that of the sovereign alone. Nullum tempus occurrit republicae. Her grantees, though artificial bodies created by her, are in the same category with natural persons. All right? So that's telling you you're on equal footing. Every person can be taken to court and sued. Why are you letting these things, these cities, these counties, these states treat you like shit? Why are you letting them extort and exact you? It is your right, of course, to be extorted and exacted, but at the same time, it's your right because you don't fight for your right not to be extorted and exacted. You just pay the bill, or you let it go and they foreclose, whatever. They win either way. But we forbear to quote further authorities on the subject. We hold the doctrine to be well settled. You're not going to change this. What may be the rule in regard to perpestures and public nuisances by encroachments upon the highways and other public places is not necessary to determine. They are generally offenses against the sovereign power itself, and as such, no length of time can protect them. Where the right of property in such places is vested in the municipality, an assertion of that right may or may not be subject to the law of limitations. Again, we express no opinion here. That the action is found on a statute and that the statute of limitations does not apply to actions founded on statutes or other records or specialties, but only to such as are found on simple contract or on tort. Where does the statute of limitations apply, and why are you always a victim of this notion of statute of limitations? Oh, I'm sorry, sir. 3 years, but you didn't sue within 3 years, so you know statute of limitations is up. Therefore, the criminal activity that you are trying to make aware to the court cannot be seen. Sorry, that was because you're in a contractual relationship. Now, unfortunately, when you I have this in my book, when you are a United States citizen, you have no right to a tort. That's the real big downfall of citizenship. And again, that's explained, so I'm not going to go through that. But again, where do statute of limitations apply? They apply to contract. To what is a municipal corporation? Well, it's a contract. It's a compact that's created to create, with permission of the state, of the sovereign, to create a municipal corporation for the governance of the local whatever, right? Sewers, that kind of stuff. Okay, it is a contractual relationship. It can be, therefore, under the statute, it is therefore not immune to the statute of limitations. It is an action on the case upon implied assumption arising out of the defendant's breach of a duty imposed by statute and the required performance of that duty by the plaintiff in consequence. Now, how many times have I told you? What is citizenship? It is called a performance debt, not a monetary debt, but a performance debt. Okay, so what does this say? In this particular action on the case, it is an implied assumption arising out of the defendant's breach of a duty imposed by statute. In other words, the person, the individual, the straw man, must perform a duty that is imposed by whatever statute they create. You don't have a choice. And the required performance of that duty by the plaintiff, i.e. the person, in consequence, right? What is that telling you? You're a slave in a performance debt. Whatever statute they pass, you follow. This raised an implied obligation on the part of the defendant. Implied obligation. Everything is implied, right? Even the contract is implied. That doesn't make it illegitimate because it's perfectly acceptable to have implied anything. The problem is you're not saying no. You're not rebutting any presumptions. You're not rebutting any of these assumptions. This raised an implied obligation on the part of the defendant to reimburse and pay to the plaintiff the monies expended in that behalf. The action is founded on this implied obligation and not on the statute, and is really an action of assumption. The fact that the duty which the defendant failed to perform was a statutory one does not make the action one upon the statute. Okay, what's the difference? What's it saying here? You have the defendant was supposed to perform some duty according to the statute. Okay, the money that he has to pay for not performing that is not based on the statute. This is why we call them sanctions, right? Any punishment that you receive, any payment you have to make, any fee you have to pay for such bad behavior, for not assuming or not actually fulfilling the duty that you have to follow all these municipal laws or statute laws, is in fact a sanction. Sanctions are separate from the laws, right? So it's telling you that the fee itself is not based on the statute. It's based on the fact that you didn't perform your duty. That's how extortion works, right? I mean, if I'm a if I'm any other mafia member and I come to you and I say, hey, we'd like to take 20, we want you to pay us 20% of your take. We want you to also deliver a pound of bacon and 3 pounds of sausage to this address every week, right? I don't even have to tell you what your punishment's going to be if you don't do it. I just do it. Next week I come in and say, hey, man, we didn't get our sausage. Where's our sausage, man? You gave us bacon, but no sausage. You said, please, sir, I didn't have enough sausage. I gave you extra bacon, but we didn't ask for extra bacon. We wanted our fulfillment of sausage. You did not perform the implied duty of this unwritten contract, and therefore, we're going to kill your children. We're going to, I'll tell you what, you pay me now 6 pounds of sausage, and we'll call it good. You see, I've just charged you, I've just sanctioned you. The sanction has nothing to do with the statute that I created out of thin air. Nope. No, I'm sanctioning you. I'm saying if you don't pay, well, then you're going to have a lot of problems continuing to fulfill your duties. You're going to have a lot of problems. We're going to sanction you. We're going to charge you more than you can afford and put you out of business. Or we'll just burn you down. Right? There's no difference here. This is what it's saying. The statute, because you didn't perform some duty, some obligation, some action that had nothing to do with money, well, we'll forgive that if you give us money. That's all it is. Has nothing to do with the actual statute or its performance. It's just extortion. It's patently ridiculous. But we don't say no, do we? We don't say, hey, wait a minute. Nothing in this statute says I owe you money. Nothing in this statute says you have the right to. I'm going to take you to court, person. I'm going to say, no, person. You can't do that. Just like my neighbor can't do that. Hey, I borrowed my neighbor's lawnmower the other day, and we kind of agreed implicitly or had an implied agreement that I would return the lawnmower in 2 days, the next day or after I'm done with it. But you know what? I got so busy, I just stuck it in the garage, went on, had to take the kids to school, etc., etc., etc. You know what? It took me 4 days to get back his lawnmower, and because he had to come over and ask for it, he is now charging me and sanctioning me and saying you owe me money for not returning, not fulfilling your implied duty. And therefore, here's a bill. I'm going to say, hell no, neighbor, my fellow person. Why would I do that? No, I'm going to take you to court and I'm going to prove that, just because I didn't perform some implied duty doesn't mean I have to give you money. Did you ask why I didn't do it? Is there some, was there an explanation? Oh, no excuses. No excuses. See, this is how the system works. It's a very bad system. Why we put up with it, I don't know. I really don't know. Let's see. Again, implied obligation, failed to perform. The fact that the duty which the defendant failed to perform was a statutory one does not make the action one upon the statute. So again, trying to make someone pay, and yet that payment cannot really be connected to the actual statute, because the statute doesn't say you're going to pay us this much if you don't do this duty. Again, sanctions are completely separate. It's organized crime. It's clearly an action described in the statute of limitations, etc., etc., etc. It was held by this court that the liability of the stockholders arose from their acceptance of the charter and their implied promise to fulfill its requirements, and that the legal remedy to enforce it was an action on the case to which the statute of limitations would apply. Again, the municipal corporation, in acceptance of its charter, had a duty. There's a lot to this case. That's essentially the end of the section here. But what is the point? What am I trying to teach here? Okay, it's by saying that there is no statute of limitations, really that goes back to the Roman law, right? Sovereignty is another word for kingship. What is the maxims, the principles of law that apply to the sovereign or to the king? Okay, I'm going to read a couple for you. 1, time, as in statutes of limitations, which are based on time, calendric time. Time does not run against the king. A sovereign has no clock. It has no limitations. It has no law. So how can you possibly say that a king has only a certain time to act in a certain issue? No. The king is in complete lawlessness, except for the laws that he agreed to be king, or that the corporation created upon his kingship. Again, no time or place affects the king. Oh, so it doesn't matter where the king goes, he's sovereign, and there's no statute of limitations. Again, no time runs, i.e., time does not run against the Commonwealth or the state. Well, there you have it. Commonwealth is essentially the United States of America, and transferred into the United States, a corporation, and so time does not mean anything. You see, they put us in the time domain, because the only way to control us is in the time domain, to limit, to have limitations, to have such legal statutes that say you must do this by a certain time. Imagine if a police officer gave you, for instance, a ticket, and that ticket said, you were speeding, you broke the law of the god of speed, and therefore you owe this much money. And that's all it said. And you say, well, okay, I'll pay that when I'm dead. I'll pay that right before I die, or maybe I'll die before, and tough luck. Sorry. What are you going to do when I'm dead? Right? See, they have to keep us in the time domain. They have to keep us on the Roman calendric time. They're in a completely different time, right? Their year, I don't know what the Jewish calendar year is. It's 55 something now, I think. 55, 65. I can't remember. Right? They're way ahead of us. We're acting as history. We're acting as historical characters. We're in 2017. They're in 55 something else, right? So we're just we're dead. Right? We're history. That's how we operate. We're dead persons. By no agreement can it be effected that a fraud shall be practiced. Fraud will not be upheld, though it may seem to be authorized by express agreement. And that's talking directly to you. That is a maxim of law. Again, what's it saying? Fraud cannot be upheld unless you say it can. That includes silence. If you don't fight anything, well, then it stands. You can't call something fraud and enjoy the benefits of the fraud. I can't tell you how many times I've said that and nobody seems to listen. Here's an interesting one. The old feudal law, a maxim that says no land without a lord. See, land is another one of those terms that is a legal term. It doesn't actually mean land. It means title. It means, again, a flattering title that says you are the lord of some land. Okay, that's what private people are. Make no mistake. They're the land. They're the modern day feudal landlords, except we don't have a feudal system. Instead, we have an allodial system, and they are granted perfect title by the lord, which is the allodial holder, the state. The state holds the land. It grants perfect title. No man is sovereign, but they do become sort of kings over their own land. Lords, if you will, over their own lands. Does that mean that they're not subject to allodial, or excuse me, eminent domain? Of course not. The state constitutions are very clear that everyone, including private landholders, are subject to eminent domain. You have to agree to certain things, of course, to be to have that title, that privilege. And I say again to people, I'm not stopping anybody from going private. I'm not stopping anybody from being a state citizen. I know how to do it. In fact, I had a gentleman contact me the other day, tell me how he did it. Another one. There's been quite a few, starting with KW. But does that mean I support it? Does that mean that I say, yeah, you should go ahead and do it? Yeah, I'm not so sure, because to me, you're again, what are you becoming? You're becoming a feudal landlord. The difference between the feudal system and our system is that no man is sovereign. That means that, in other words, that yes, you're a landholder. Yes, you have perfect title. Yes, you have private law that is not your own, but you're still a person. You still have a person, a status. It's just a private status, and it's not your own. And you, the reason you're not sovereign is because you lord over no one else. You have no subjects, therefore you cannot be a sovereign. And this is why they say that God, i.e. Jehovah, is supposed to be every man's sovereign. If God is sovereign, then no man can be sovereign. No man can be sovereign unless he rules over others. So get this stupid idea that you can be sovereign, which would mean that you have more power than the state itself. You cannot ever have, and this is a maxim, you cannot ever have a power, an authority, a title granted to you that is higher than the grantor. The state cannot make you anything but less than itself. It cannot even make you equal. It has to be a status less than that which is granting it. And this is why you cannot hold a lodial title. Only the state can. But the state can grant a landholder, a landlord, a perfect title. But you can never have, while you're inside the matrix, you cannot be outside of it. When you're inside the legal matrix, you have flattering titles and personas and masks and all these things. You can never be higher than that which granted you the authority, the power, the title, the person in the first place. That is such a self-evident truth that I don't even know why I have to explain it. And yet the whole patriot sovereignty movement is based on the notion that you can somehow do that within their system, that you can be higher than the state. That's impossible. It's literally impossible unless you break free of their system. You see what a person is. You see what a state is. You see that they're just corporations. They're artificial persons. And you stop following their laws, and you go back and you get reborn, regenerated back into God's law, back into the law of nature. All of a sudden, your sovereign is God. And they acknowledge the act of God. They acknowledge the nature as higher than fiction. Suddenly you are higher than the state. So, again, do I promote state citizenship? Yeah, I probably would say it's a first step to get outside of to quit your United States citizenship and go be what the intention of citizenship was supposed to be, the quote-unquote republics, etc. Yeah, I would say that's a good first step, but what are you going to do from there? Because, really, you're just becoming a master instead of a slave. Is that really a better title? You're now living off the backs of the public people as a private person. I don't think that's a good thing. I don't think that's a good thing. You tell me you spent this whole time figuring out this whole system only to be granted a title within the empire, right? You fought Darth Vader this whole time, and he gives you a seat at his choking right hand. Really, I mean, is that really why you partook on this whole journey, just to settle for some higher status than you already have? See, this is why I'm not keen on this. It is a route I will probably follow, only because I believe it will lead to a means to an end. But I'm still undecided, honestly, on that aspect. The choice, the time to make such choices, I think is falling by the wayside very quickly. So, I don't know what to say, folks, other than we know that we're in the bottom tier. We are the plebes. We are the Borg, right? You think when those guys named the in Star Trek, the Star Trek series, when they named them the Borg, that they didn't do that for a reason? Look up the word Borg. Do you think it's not a real term? No, it means the commonality. It means the bourgeoisie. It means all the people that they wanted to eliminate in the Russian Revolution. The Jewish, quote-unquote, Russian Revolution. Trotsky, Lenin. Kill all the white farmers, the Christians. Kill them all. Kill the Borg. Do you think that Star Trek isn't portraying those machine-like automatons? Do you think that the writers didn't understand that when they called them the Borg, that they were calling all of us who are watching that show every week, all of us idiots? They don't think they were portraying us in that character as the Borg, as the public, to be managed, to be administrated, to be chipped? A warning of what will happen if we're not controlled. Planet eaters. Yeah. Anyway, there's a lot of maxims that I could cover, but I think we'll move on here, because there's some other things. There's one that I do rather like, and I want you to understand this, because this is actually what the Bible attempts to tell you, and it's not clear in the Bible, but this makes it very clear. There is no fiction without law. Now you go through the Bible, and it's constantly saying that men are caught up in the law, that the law is what makes things evil. Law is what allows anarchy. Law is what allows lawlessness. Law is what is again, you give someone a license to do something that is against the law, suddenly it's not against the law. You see, therefore, fiction, which is opposed to reality, opposed to God, opposed to nature, opposed to the law of nature, fiction cannot exist without law. What are we talking about? We're talking about persons today, right? We're talking about states, countries, nations. We're talking about cities, counties, districts. They're all persons. They're all fictions. You see, they're fictional characters. They're persons at law. What did it say? They're persons at law. Without law, there can be no fiction. What does the Bible say? You cannot follow two opposing laws. The Bible law says no fiction allowed. The legal law has no other purpose than the creation of fiction. Legal fiction, fictional characters that we can hide behind and pretend that we're not responsible for our actions. Now, in these last few minutes that we have here, I want to make sure that you understand, as a citizen of the United States, that you are not the sovereign people as described as the creators of the Constitution, etc. Now, I said before There was a debate as to whether they should say we the people or we the states. But it's important to understand that when these guys were together and they were signing the Constitution, they were representatives of the states, of the peoples that made up the states. And this is why they said it was for the white persons, themselves, and their posterity, okay? You know, remember, white persons has nothing to do with color of your skin. It has to do everything to do with your blood, your lineage, okay, your arms, your family arms. So let's go over this real quick. Maybe this will give you a better understanding here. I'm going to read from several court cases. The authority of the organic law is universally acknowledged. It speaks the sovereign will of the people. Its injunction regarding the process of legislation is as authoritative as are those touching the substance of it. The Constitution shall be the supreme law of the land. Those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes on the Constitution and see only law. The Constitution of the United States was ordained and established not by the states in their sovereign capacities, but emphatically as the preamble of the Constitution declares, by the people of the United States, capitalized, so specific people. The government of the Union then is emphatically and truly a government of the people in form and in substance. It emanates from them, not us. Its powers are granted by them and are to be exercised directly on them and for their benefit. Now, why is this important? To understand that you are not them and they are not you. That they created the United States to hold you in debt slavery. Why is it important? Right? Why is it important to acknowledge that you don't have the rights or rights of the Constitution? It doesn't apply to you, because remember, it applies to the people, the private people of the states who got together and created it. But what it does not apply to is a creation of those people. They created the United States. It's subservient to them. And therefore, the Constitution doesn't apply. You don't use it. You cannot use it as a declaration of a right. It doesn't apply to you because you didn't reserve all your rights. And it's a negative document that says government can't. Well, there's nothing that government can't do to you that's not written, because you don't have any reserved rights. We have already had occasion in considering the nature of the Constitution to dwell upon the terms in which the preamble is conceived and the proper conclusion deductible to it. It is an act of the people and not of the states in their political capacities. It is an ordinance or establishment of government and not a compact. Though originating in consent, and it binds as a fundamental law promulgated by the sovereign authority and not as a compact or treaty entered into fiery between each and all the citizens of the United States as distinct parties, not a compact between each and all citizens. The language is we the people of the United States, not we the states, do ordain and establish, not do contract and enter into a treaty with each other, this Constitution for the United States of America, not this treaty between the several states. And it is, therefore, an unwarrantable assumption not to call it a most extravagant stretch of interpretation, wholly at variance with the language to substitute other words and other senses for the words and senses incorporated in this solemn matter into the substance of the instrument itself. We have the strongest assurances that this preamble was not adopted as a mere formula, but as a solemn promulgation of a fundamental fact vital to the character and operations of the government. The obvious object was to substitute a government of the people for a confederacy of the states, a constitution for a compact. The difficulties arising from this source were not slight, for a notion commonly enough, however, incorrectly prevailed that as it was ratified by the states only, the states respectively at their pleasure might repeal it. And this of itself proved the necessity of laying the foundations of a national government deeper than in the mere sanction of delegated power. Okay, what is this saying? It took the power away from the states. You see, this is not a good thing that the power was given to only a certain group of people. It took the power away from the states. See, there's the Confederacy and its articles and everything. That was the original, and it never went away. And all they did was transfer the power from the states to this group of Masonic men and their posterity. It's not a good thing, and took God out of the picture, took God and religion out. The states, respectively, at their pleasure, might repeal it. Proved necessary of laying the foundations of a national government deeper than and more sanction of delegated power. So right there, it's telling you states can't secede. In other words, the states cannot say, okay, this Constitution is not working. The convention determined that the fabric of the American empire ought to rest and should rest. Well, American empire should rest on the solid basis of the consent of the people. Not you and me. Don't get that wrong. The streams of national power ought to flow and should flow immediately from the highest original foundation of all legitimate authority. And accordingly, the advocates of the Constitution so treated it in their reasoning in favor of its adoption. The Constitution, said the Federalist, is to be founded on the assent and ratification of the people of America. Given by, but you're the people of the United States. There's a big difference. The corporation. Given by deputies elected for that purpose, but this assent and ratification is to be given by the people, not as individuals composing a whole nation, but as composing the distinct and independent states to which they belong. This is why the word states and people are synonymous. Okay. And the uniform doctrine of the highest judicial authority has accordingly been that it was the act of the people and not of the states, and that it bound the later as subordinate to the people. All right, now I want you to understand what this means. This would be like if our Congress today got together, created a new constitution for strictly themselves and their posterity without consulting the states that they're representing. Right, you get it? They took over the power. They took the power away from the states by creating the Constitution. They didn't give power to the states. They allowed the states to retain some of their sovereignty, but not all. They're quasi-sovereign. This is not a good thing. Let's see. Themselves and their posterity. Collectively, they comprise everything requisite with the blessing of divine providence to render a people prosperous and happy. See, a people, again, is capitalized. The words people of the United States, this is where we start explaining things here. The words people of the United States and citizens are synonymous terms. Remember, we're talking about pre-Civil War here. This is back when we called it legitimate, even though it never really was. The people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. That's referring to the people in the states, not United States citizens, which are a creation after the 14th Amendment. They're what we familiarly call the sovereign people, and every citizen is one of these people back then and the constituent member of the sovereignty. The question before us, and here's where you find out what you are. The question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not. And that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. Right? Remember, we're talking about the difference between United States citizens. This is in the Dred Scott case, by the way. Difference between United States citizens and those who are the posterity, those who are the private bloodlines, the landholders, the states, of people of the states, were not intended to be included, in other words, citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at the time considered a subordinate and inferior class of being who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. It is not the province of this court to decide upon the justice or injustice of this, of that laws of that time. In other words, the decision of that question belonged to the political or lawmaking power, to those who formed the sovereignty and framed the Constitution. It's making a clear distinction. So what did they do? We created the United States citizenship. All these Negroes, for instance, who didn't have citizenship, suddenly they were granted citizenship within what? The United States. United States Corporation. Seated in Washington, D.C., as we read. And after that, even though it was intended for these particular people, all of us who would qualify as state citizens, as the posterity, etc., were tricked into the birth process, into contracting implicitly and an implied contract with the United States. Because remember, it applies to all the inhabitants of the District of Columbia and anyone that contracts with the United States, the District of Columbia, excuse me. And that's what we've all done. You see, we're not the sovereignty or the people, as I am not the people and neither are you. All right, I wrote a blog about this. You got to understand the power that has been taken away from you so that you can understand that the stories we are told about how we are all the people and how we are that is untrue, because we have contracted with the district, with a foreign entity, a foreign corporation, and therefore our place in the States is as foreigners licensed to be there through the agency relationship. Now, we are, I believe, out of time here. So I need to wrap this up, and we'll continue this next week because I got a lot more information to share with you on this that shows, including the importance of in all, in court and everywhere else, the importance of maintaining the Christian religion, referring to the Bible, not to any specific religion organized, but to the Bible itself as the foundation of law. That is all over the place in the old documents, and you can see what's happening because that we have lost that, including the Civil War in the United States being created to house all of the slaves, all of the voluntary slaves that we are. Until then, I'll stop there and wish you a wonderful day. Thank you for joining us here on UCY.tv. This has been another episode of Red Pill Sunday School with Clint. Hope you have a good day. Take care.